One of the common misconceptions these days about bankruptcy relief is that an individual who has above median income is not eligible to file bankruptcy or obtain relief in bankruptcy. And this is simply not true. In 2005, the law was changed to introduce means testing in bankruptcy, and there's a somewhat complicated calculation that must be done to determine DMI in Chapter 13 cases and whether an individual might be eligible for Chapter 7 relief, or there might be a presumption of abuse for that individual to get bankruptcy relief. Now, under means testing, the first part of the equation is income, and the critical aspect is for the average monthly income that individual and his or her family has received, household in Virginia during the last 6 months. If you annualize that figure and factor it as a monthly income figure, is that above or below the median income for that household size in Virginia? If the median income is greater than that individual's monthly income under the means testing, then the inquiry stops there and there's no presumption of abuse. If the individual has income greater than the median household income in Virginia for his or her family size, then we go on to a second part of the equation, which are expenses. The individual is entitled to claim really two different types of expenses. One are expenses that are given to the individual according to IRS or Census Bureau standards for Virginia. What are the costs that they'll allow you for the operation or ownership of a motor vehicle, for instance? What are the expenses that they will allow you for food and utilities and household expenses that are not mortgage expenses in Virginia? And so you're given a certain set of expenses, and then you're also allowed to deduct as expenses certain actual expenses that you might have. For instance, a mortgage payment on a home that you're going to keep, your car payment, if you owe child support. And after looking at your average monthly income and these expenses, both that you're given and that you actually have, the end result of this complicated calculation is DMI, disposable monthly income. In a Chapter 13 case, that's what you might be required to pay to your unsecured creditors in the case. If you show an excessive amount of disposable monthly income in Chapter 7, it will raise a presumption that allowing you to get a bankruptcy discharge would be an abuse. Now, you still can overcome that presumption. It would be your burden to convince the court that it wouldn't be an abuse to allow you to get a Chapter 13 case. And also, you may prove special circumstances to affect the bottom line of means testing. You can show why, for instance, the calculation doesn't accurately reflect the situation that you're going to have in the immediate future, and the judge should disregard that. So it's not as simple as, am I above median or below median income? There's a much more complex calculation that must be done to determine both your eligibility for bankruptcy relief, and if you're in Chapter 13, what amount you may have to pay to your unsecured creditors in your Chapter 13 plan. You should consult with an attorney in your area to discuss means testing in more detail so you can better understand this before you make the decision about whether to file bankruptcy or not.